So good morning, everybody. Welcome back to another Sunday School. We're joined this morning by a tremendous advocate for parents' rights, fathers' rights, family rights, Brian Ludmer from Ludmer Law. We're going to be talking about both false allegations and what happens when the Children's Aid Society or MCFD is involved. Brian, thank you very much for being here and for giving us your time this morning. I'm sure there's lots of people who are quite excited to hear what you have to say. So I'll let you take it away. Thanks very much.
Thank you. And I'll screen share two presentations. So we're going to go through this at a fairly high level. These are presentations that I gave at the 2023 Men and Families Conference and the 2022 Men and Families Conference that just resonate perfectly with what Gavin has asked me to speak to. So the screen sharing we tested, it should hopefully work. And here, therefore, is the one that Jenny Kirshen, colleague of mine, and I gave just this year. So the first part of this presentation is all about how Children's Aid Society works, and I'm going to just skim through that part because there are some tips and tools in dealing with them that are important to understand when you're refuting false allegations that have been brought to them. It's a very typical tactic, and indeed the various Children's Aid Societies frequently have never heard of a family, and then once the family gets separated, there's a constant dialogue of complaints. It's almost as if the targeted parent suddenly forgot how to parent, suddenly picked up all kinds of maladaptive, impaired parenting practices. It's just not sustainable logically. And the unfortunate thing is that society workers are not trained in high conflict family dynamics. They're not trained forensically, how to think forensically, how to review matters brought to them forensically, as we explored in detail on a false allegations of sexual abuse trial that I did earlier this year. Some of them at the outset of their careers get some training in forensic interviewing, but it's not training that they repeat year after year after year. And so they fall into bad habits of interviewing children suggestively, but none of them get trained in thinking forensically and analyzing disparate narratives given them forensically. And they have a very narrow lens, and so quite often they're not only unhelpful, as you'll see with some substantial quotes that I've got from two cases, they align themselves with the person making the allegations. So when we go through some of the cases I've been involved with where the society got it wrong, and then sometimes flips, and they when they finally see the light, then they become your best friend because they're seeing it your way, which is quite unfortunate because they have such a powerful and tremendous role to play that it's unfortunate that very often they get it wrong at first. And I'll explain why they get it wrong in the course of the first part of this presentation. The second one, when I pull up 2022 presentation, and again, I'm only going to be able to deal with these at a high level. I want to cover a broad range of topics and hopefully leave some time for answering questions. You'll see that often we're in a position where we have to prove a negative. We've been accused of X. prove you didn't do it. So it's the proverbial, how does one prove a negative? And having dealt with false allegations nonstop in all of my cases, I have a rubric. I have a plan for how you prove a negative, even though everybody should acknowledge that from a purely theoretical perspective, if you've been accused of something, the only way to 100% prove a negative is to say, wow, everybody's very clear, or the accusing parent is very clear that this happened in this context on this date. Here's my passport. I was traveling on business in Europe that day, so it can't possibly be true. Or isn't that interesting because my father, my brother, my friend was with me at that event. And here's their affidavit saying I was there the entire time. And this allegation isn't true. This child was never out of my sight the entire time. What is alleged here simply didn't happen. So, aside from the purity of those two situations, proving a negative is by inference, assembly of background facts to show that the allegation, either temporally or in terms of its content, is inconsistent with a family history or is inconsistent with how people would have acted at the time, in the moment, if it was true. So we used to say, prior to drones and webcams, if I was a fly on the wall, and if this was true, what would I have seen? I would have seen mom act this way. I would have seen dad act this way. I would have seen child act this way. I would have seen the manager of the store being called over to deal with this incident. These are the things I would expect to see. Instead, 3 months after the alleged incident, one parent is being accused of X, Y, and Z, but the content of that is inconsistent with logically what one would have expected to see in the actions of the people involved during, immediately prior, immediately afterward, if it were true. So it's kind of by inference and logical or forensic analysis, the very thing that society workers are absolutely positively 100% not trained in. So now you see the challenge of it's hard to deal with false allegations to start with. There's this taint of almost guilty until proven innocent. And the people who are supposed to be protecting the child and acting as an arbiter, so to speak, of the veracity or not, or gross exaggeration. Remember, that's a possibility, right? There's a tiny, tiny kernel of truth. And they've, like the shell of a clam or oyster, it just builds up over time. It has expanded to such an extent it bears no relation whatsoever to that tiny kernel of actual truth buried deep within. And so, to use a similar analogy, we then do the opposite. Imagine an onion. We peel back the layers of the onion to get at the essential truth. These are all visuals I can give you of the detailed, granular process involved in thinking forensically about an allegation. And society workers, for the reasons we're about to see as I get into presentation one now, are unfortunately singularly unsuited for this task, which is a sad tragedy. So here we go. Everybody, if I could just get a thumbs up, you should all be seeing this 2023 presentation on screen. Okay. So I said that this was Jenny's part of the presentation, which was an overview of what a children's aid society is, its components, its tiered hierarchy internally. And on this particular slide, there's actually a live link. So if anybody's interested, I can email you these at the end of the day, a live link to this YouTube documentary, Powerful as God, Children's Aid Societies of Ontario. And it's a litany of stories. And I'm going to be giving you my own stories on the back end here of how they get it wrong and the unbelievable power that they have. Now, so before we get into structurally what a children's aid study looks like, got to understand one other thing about the authorizing legislation, which in Ontario, in case people from other jurisdictions are seeing this presentation, it derives from the Child, Youth, and Family Services Act of 2017, which was an evolution of the pre-existing statute, which was the Child and Family Services Act. There are two principles that are supposed to be limiting factors or guiding philosophies of society involvement. Their involvement, because they use the powers of the government, triggers charter rights, and there's extensive jurisprudence about that. When you're dealing with a society, you have the utmost in procedural and substantive fairness rights. In the legislation, it says that their intervention, their footprint in a family should be guided by various principles, but I want to highlight two. One is take the least intrusive intervention possible that will be of assistance in protecting the child from risk of physical harm, emotional harm, psychological harm, etc. And they often forget that. They threaten, you're going to do this, you're going to go do this, or else I may take the child away from you. Well, it ain't that simple, and you're overstepping, and please stop bullying me. You've forgotten your legislative mandate, which, by the way, in case I would otherwise forget to say this, we always, your charter rights are triggered, we always have somebody else there, a support person. Grandmother, grandfather, friend, brother, sister, some other adult. When we interact with society, caseworkers, or investigative workers. Always, always, always. Because that's the only way we can control what they decide to write down and what gets into CPIC, the online database, which is their official record. And these society workers, they get full of themselves. So by having a witness there, and you can be interacting, playing the role as the parent, interacting, answering questions, the other person is just there, silently sitting there, taking notes. That ensures that this worker doesn't go off and do something silly. And they may object, but it's your absolute right to have somebody there. And it's like, it's not that I don't trust you, but we have different perspectives and stuff, and you may have questions for this person because they They know the kids as well and whatever, but like, this is my support person. They have to allow that. The only time they can object is if your purported support person is your lawyer. Then they say, oh, well, that's not going to work because then we need our lawyer there, which often happens for meetings discussing the allegations or the society positions that take place at the society offices or otherwise. So you'll have your lawyer there, they'll have their lawyer there. It just complicates the scheduling. You're entitled to that. But for the, let me talk to the child, let me talk to you, let me see what the home's like, etc., you have a support person there always. Okay? Are you entitled to record those interactions? Yes, you are. They may object, but if you want to turn your phone recording on, keep it in your pocket, you're absolutely entitled to record those interactions. As you know, under our law, if you are party to the conversation, you're part of the conversation, you're not recording somebody else's conversation, you're allowed to record. There's certain states in the United States where that's illegal. We're talking Ontario in particular. Okay. Now, I mentioned one of the principles, the least intrusive intervention. But there's another major principle that the workers frequently forget, which is the purpose of the agency and its exercise of power is the rehabilitation of families, not the splintering of families, not the finding of fault, not the aligning with one parent at the expense of the other parent. It's rehabilitative. It's not just about making a finding and finding fault. It's how can we have the healthiest possible environment for this child? And so some of the mistakes that these workers do, and I unfortunately see it all the time, they start to delve into custody and access matters. What parenting plan? No, you've left your lane. Your lane is to deal with child protection matters. How much time with one parent or the other is for the private family litigation statute, not for the child protection statute, which itself, by the way, is based on best interests. But the philosophical approach is, how can we as an agency help the family, supports, learning, do better, don't act this way, get some medical help. You're suffering PTSD, it'll help you be a better parent. Child's needs in terms of academics or whatever not being met. How can we all do better? So if they're purporting to make findings, it should all be within the spirit of least intrusive and family rehabilitation. Not, oh, deficient parent, we need to protect the child from that parent. They're missing the rehabilitative aspect of their purpose. Okay? All right. This is a slide that just deals with structurally, if it's a fresh allegation, you'll be dealing with the investigations unit. If it's just part of the same old, here's another complaint and they're already providing services, it might be dealt with by the ongoing caseworker. Now, caseworkers, because they're not trained and they have much less experience, often get it wrong. Each supervisor might supervise, depending on the size of the agency, 3 or 4 or 5 caseworkers. Plus, they have their own administrative functions. So how much time does the supervisor have for any one particular family? Not that much. And what they learn about a family is frequently going to be filtered for them by the caseworker. So they're not going to get a 360 view to be able to say to the caseworker, oh, okay, I see why you're saying that, but I have 15 years of experience. Here's what you may be missing. Have you asked the family this or that? They may never get there. They may be harried and, okay, we're going to talk about, you want some input on family A, I can give you 10 minutes. And then they get a bunch of filtered questions, which they answer, but they haven't been able to apply their own much more experienced independent thought to the issue. Supervisors are managed by another level, service managers, sometimes called different things. They may supervise 3 to 4 supervisors. So if you do the math, that might be 16 to 20 families that ultimately one particular service manager, whatever that title is at a particular agency, might be responsible for. How much time do you think they have to really get to understand a dynamic in one family? When you go up another level to the director of service, you're into something that is much more administrative, supervisory, training, reporting, budgeting. But you need to know these levels because every society has both an informal and a formal escalation procedure where if the worker's not getting it and you know why the worker's not getting it, you're going to ask for a meeting with the supervisor. And the supervisor won't have gotten that 360 view. You're going to give it directly to the supervisor. You are entitled to that meeting. Still having a problem? You are entitled to meet with the service manager. And at that point, you're probably bringing your lawyer in as well, and they'll bring their lawyer, and you'll really get to the bottom of what's going wrong here. And then, yes, the formal procedures would enable you to escalate the matter to the director of service and ultimately to the executive director, and even then to the board of directors, even though hard to get a forum with the board of directors, but you can write them. So that's something to know if the caseworker or investigation worker is not getting it because they're blinded, they have an improper lens, or they're not able to think forensically. So if you look at the right-hand column of this slide, you have a summary of some of the difficulties and challenges in dealing with children's aid societies. But the logical flaws in their reasoning and thinking is probably the biggest problem. But these are here for a reason. These are common things that we, as lawyers in assisting clients in navigating children's aid societies, run into. And if you look at this point here, errors in record keeping, that's why we always have a support person. So we can say, well, wow, that's interesting. We read that record. Well, you left out this, you left out that, you left out this. And no, I did not say what you reported. You got that wrong. Here's my friend who was there the whole time. They know what I said. I know what I said. You were harried. You wrote it down 24 hours later. You got it totally wrong. You were thinking about what you needed to do that evening. You did not capture what I in fact said. Okay. When you're having to deal with them, set them straight. This slide tells you some of the things that we do. And again, I'm happy to provide the slide deck. I don't have time to kind of linger on every single slide because I want to get to some of the sexier stuff, the actual errors. Here, this slide, of course, you see you have witness, support person present, confirm interactions after the fact. Nothing helps you more. And this would apply, this good practice for just about any interaction with a third party, a therapist, a custody and access assessor, a parental coordinator. So you have some sort of interaction, and there's some to-dos and there's some key points you were trying to make. Write them after that. Thank you very much for coming to my house and meeting with me and my friend John and the child. To assist you, I'm just going to remind you that I made this point and that point and this point, and I responded to my ex's accusation in this way, that way, this way. And the to-dos that we all agreed to at the meeting, you, the caseworker, were going to follow up and do X and Y. I, the parent, was going to follow up and do A and B. And we should stay in touch and make sure that that happens. Once again, thank you very much for having come and seen me with my child. That letter becomes part of the official CPIC record. Your spin on what happened and what was said and what the follow-ups are becomes part of the official CPIC record. You are no longer solely dependent on what that worker chose to write into the official CPIC record. And so for that reason, this practice, whether you're dealing with a therapist and a custody and access assessor, whoever it is great practice to what we call controlling the record. Okay? All right. I'll just move here. I mentioned the internal escalation process. There's also the Child and Family Services Review Board, but they're relatively toothless and they often won't act while a matter was going on. So it's not something that's really going to solve these problems when CS gets it wrong. This slide here is really more for lawyers, so I'm going to. Okay, so now we get into some specific examples. And one of the greatest pieces of legal scholarship when it comes to calling out the society for getting it wrong, for aligning with an alienating parent, for example. Because remember, these dynamics are counterintuitive. You have one parent and the child or children saying one thing, and then you have the and so they're quite calm and confident and happy about this situation. Everything is aligned on their side. Then you have the other parent who's being victimized by the subject matter of today's presentation, false allegations, and they're out of sorts, upset, frustrated, scared, generally don't present well. An untrained worker is going to fall prey to the counterintuitive nature of separated family dynamics. Justice Hughes, in a fantastic piece of legal scholarship, called out the CS worker for aligning with the wrong parent. Arguably, they're not supposed to align with either parent, but they're not supposed to align with the narrative of an alienating parent. Alienation itself, according to our science and our jurisprudence, is itself family violence, coercive control, abuse of children. That's rock solid. There's tons of jurisprudence, tons of science. The workers are never, in my experience, trained in how to do a differential diagnosis in cases of false allegations and parental concerns about parental alienation. Simply untrained. Justice Hughes called out a particular worker and a particular society. In this case, there was a 2019 compliance motion and then a 2021 compliance motion where Justice Hughes reversed primary residence, said offending parent, in this case, the father, had too many chances, was never going to allow this child healthy development, and it was upheld by the Court of Appeal. I don't want to get into the legal technicalities. There were some very interesting issues from a legal perspective. It's really, what did the worker get wrong? What did Justice Hughes say? Why can we therefore always point to this case as a microcosm of what we're dealing with and use it in other cases? Here's what Justice Hughes said. So these are particular excerpts. Now, for some reason, probably because of COVID, this particular Bouchard versus Scovio case is not available on the public CanLII. If anybody's interested, I'm happy to email it to them as well. Sorry. If this is the 2021, then it is available. The 2019 is not available on CanLII, where fines and penalties against the offending parent were put into place. This one is, so you'll find it on CanLII. So this is a dense slide because I wanted to make it accessible to everybody, zero right in on the best observations that Justice Hughes had. Look at paragraph 60 on the bottom right. Without the necessary training, the worker would not have been aware that parents with alienating tendencies want their children to remain angry and hostile toward the other parent and will instigate events for that purpose, especially where the children seem to be making some progress. And if you look at paragraph 53, third line, it takes considerable insight and discernment, training and experience, to differentiate between those cases that present as possibly justified estrangement versus alienation. In order to do so, it is often necessary to scrutinize parental behavior over many months, including years, etc. So all of these particular quotes are tremendous observations that everybody should read carefully, and they'll likely see those same errors in their own case. Now, I had an earlier case, long running, it's still ongoing in some form, some 15 years after separation. There were 2 5-week custody trials, one in 2011, one spanning 2012 to 2013, and a 2-week review hearing in 2016. And all kinds of financial disputes, some bankruptcy law went to the Supreme Court of Canada. This, like, you could write a book on this family. This is Justice Harper. This case was taking place in Windsor. And Here's Justice Harper's take on how the Windsor Essex Children's Aid Society blew it, was unable to help this family, couldn't see the forest for the trees. But after this decision, they were a changed agency, and they were actually very helpful to us in the lead up to the 2013 trial and the aftermath of the 2013 trial, where the children were placed solely in the father's care. They got it. They learned. They evolved as an organization. And I've had other experiences as well that after there's some definitive event, third-party observations, a judicial commentary, some revelation or mistake by the alienating parent, suddenly there's an epiphany. And I'll give you that other example. So look at 127 sub 2. In this case, the society did not attempt to see the forest for the trees. They just kept coding potential emotional abuse of the child due to interparental conflict. But where's the conflict coming from? Who's stirring the pot? Who's making the conflict? What's the conflict all about? Is one parent forever on the defensive and the other parent forever making the allegations? That's not mutual conflict. That's somebody just trying to defend themselves all the time. So some great judicial rhetoric here with a positive ending. Okay, so I'm going to cycle through some of the other stories, because the stories are a great way to get across the principles. And as I said, I'm going to try and leave some time to just zero in on probably the concluding slides of the other presentation, where I show you the secret sauce of proving a negative and still leave some time for questions. Okay. Here's a Brampton case where it took 6 years with an open CS file. And then right in the middle of the match, well, we're closing our file. There's nothing we need to do to support this family. Prior to the Superior Court of Justice saying, no, this is not a safe environment for the children. We need to make a major structural intervention in the family system. So obviously not what we need societies to do. These are all cases I was involved in, by the way. And I'm just, because of the sensitivity, you're not supposed to publicize particulars of CS cases. Hamilton, classic alienation case. Children acting in ways that are totally antisocial, classic ODD behavior, and yet in no other domain of the children's lives do they act that way. They're okay in their sports, they're okay at school, they're okay with friends' parents. They're not an ODD child. They're an ODD child only in relation to one parent. When you see a child who does not act out physically in other domains of the child's life, but is kicking and hitting and pushing one parent, not both parents, one parent, you've got yourself something artificial. It is simply not something that the mental health science recognizes as natural organic behavior. That's a child who doesn't have the freedom to be and doesn't have the language to articulate the lack of the freedom to just be and love and enjoy, acting out in a maladaptive way because they're stuck in the middle of a loyalty bind. We do not see kids who exhibit physicality in only one domain. That is a sign of pathological, maladaptive, artificial alienation of the child. Kingston. Classic alienation case, completely unsophisticated workers. When we made an overwhelming case and had the assistance of a custody and access assessor, the Kingston caseworker said to me and my client, but she's the mother. Like, in other words, I know what's going on. What do you expect me to do? Recommend that the children be protected from her? She's the mother. Complete gender focus, let the kids down approach. Absolutely an abrogation of duties under the statute to protect the children. Sudbury. Very similar to Wiggins in Windsor. Goes on forever, never heals. Children say stuff depending on whether the case is active or not active. Children say stuff that seems completely disconnected with the reality in which they're living. Fence sitting by the society. And over aligns, well, the child says it must be true. And what's coming up is a very recent case where society in, it was Peel again, literally said, we rely for reality testing and the position we're going to take on the voice of the most vulnerable member of the family system. We go with that. We don't think forensically. We don't even contemplate the thought that the child may be programmed or have a false reality or have lost critical thinking skills. If the child says it happened, it happened. Really? Well, then I guess we don't need you. We could just have a scribe meet the child, write down, and that's what happened. Then we should all act on it. Why do I need you and your whole organization? But then when we showed hard evidence of what was really going on, and they were forced to contemplate the stark reality, we had some assistance from the court, and they were shown graphically the manipulation of the child. They flipped in the same way that the Windsor-Essex Children's Aid Society, once Justice Harper called them out, flipped and became our best friends. So PLCS suddenly became our best friends once the light went on. And I'll take it. They now totally get it. But it shouldn't be like that. They need to have the expertise to think forensically, and they should not just be going on the voice of the child is 100% correct. That's what happened until proven otherwise. That's not helping families. Sudbury, that's what went on here. This one was a tragedy that ended well. Mother, primary parent, doing a great job with a child with some special needs. Has to parent the child. It was a minor issue of less gaming, more schoolwork, whatever. Father, who had paid very little attention to child, jumps in, manipulates child, cuts child off, has child live with his new partner's mother, while he and his new partner take off for London, move to London, England, gatekeep for a year. Court makes the mistake of just go voice of the child, voice of the child. There was, of course, an OCL lawyer, and the child is allowed to move to England with no therapy, no opportunity. How do we go from I'm the primary parent that is completely uninterested in the child to the child being allowed to move away, wasn't even given the opportunity to say goodbye to his mom and the maternal family? And it turned out all for financial reasons. Took about a year. We had engineered a settlement because dad had owed mom a ton of child support. It was never about the money for mom. So there was no more financial upside to him. We did kind of like a quick claim. Took about a year, kicked the child out, had a new child with his new partner. Child found himself on the street in London, England. Called my client, who rescued him, flew him back to Canada. Child's now back living with his mother. And as the last point, 2 years of unnecessary trauma for a special needs child. Failure of the court, failure of the process, damage done by the whole OCL thing, no opportunity for family therapy. We said, if the child wants to choose to do university in London, England, hey, child will have aged out, no problem. But for the child to make an informed choice before abandoning maternal extended family, mom, activities, friends, flushing it all. And as an older student who had to go to school a year back because the English system was further ahead, and this was a big kid towering over his peers in class. No wonder he didn't gel. Don't you want to do some family therapy first? Give the child an opportunity to finish high school in Ontario. Then the child could make an informed decision. But child's been cut off from mom for a year. No wonder the child says doesn't want anything to do with mom to the OCL. And the court just, oh, it's whatever the child wants, whatever the child wants. Utterly failed the child, who's now back here where the child should have stayed to start with. This one, complete disaster. Society cannot identify any reason why one child wants nothing to do with father. The other child is happily going back and forth 50-50. Dad's more than good enough parent to keep the younger child happy and thriving. How can you be a disastrous parent for one child, but some of you can make as great a contribution to the child's upbringing for the younger child? It just, human beings don't work that way. Try explaining that to a Children's Aid Society. And we're saying, can we fix it? Can we get the child into reunification therapy? No help from the society. Okay, that one didn't end well. Durham region. Extending supervision for years past when it was required. not understanding the damage of to a parent-child relationship during supervision, allowing the weaponization of an unverified concern, which only went away after the removal of the supervision requirement. You were given an opportunity to show what you could do. Complete failure of thinking forensically and understanding the damage from supervision itself. Here's another Peel case. Each year, mom would levy allegations of sexual abuse of this little boy. An investigation, interviews of the child. Remember that repetitive interviews of children leaves footprints. So we interview the children. Do you feel comfortable around parent A? Did parent A ever do anything to you? What happened on this day with parent A? Parent B is very concerned about you. It leaves footprints, even if you don't verify it, it's not verified. At some point, the child starts to worry. Why is everybody very concerned about how things are with me and parent A? What's going on? Why is everybody so concerned? Leaves footprints. By the time you get to allegation number 4, number 5, number 6, the child's mind, and I've given other presentations, and there's a whole body of law and science on how false memories form. Let me tell you that not only does no society understand the science, memory, what I call memory science, what the law calls memory science, they don't get any training in that. They have no idea how malleable, how suggestive children are. And they anchor on false beliefs about memory. One false belief about memory is that you could have delayed disclosures. No, I'm okay with mom. Yeah, no problem with mom. And then year 6, after all of this probing, I think mom abused me back when I was 4. So it takes me 1 minute to say, illogical, cannot be, not the way the mind works. Memory science tells us we lose details over time. We do not gain details over time. Buried trauma that comes to light in all its glory years later is not supported by memory science. Memory itself is a reconstructive process. We experience something. Our minds are prediction engines for 3 purposes: to avoid predation. This goes back millions of years. Avoid predation, find food, find a mate. The 3 principal functions of living. Our minds are built to help us predict that. Our minds are not built to remember, yes, we were all sitting around at the cottage on this day 6 years ago. This person said this person did that, this person. Our minds do not even capture that level of detail in the first place. We capture the essence of it, the feeling of it. Is this a safe person or not? Unless there was something very unique about it. But most of the details don't even get encoded into long-term memory to start with. Years later, when we're asked about it, our minds engage in the reconstruction of the parts of the event that we encoded in the first place. And when we reconstruct the memory, it gets tainted by our current understanding of the topic. So years have gone by. We have an evolved internal working model, or what some psychologists call a schema, about a person, about a situation, about an event. Is it good? Is it happy? Is it healthy? Is it safe? Is it a place I can get great food? And that evolved impression built on more recent memories colors the old memory when we try and reconstruct it. It gets filtered through subsequent events. Then we talk about it. Then it changes again. Then it gets re-encoded back into long-term memory, changed from the original encoding. So that's why the language that memory scientists, cognitive scientists use, memory is a reconstructive process. And the British Psychological Association has a research institute arm, and in 2012, they published guidelines on law and memory science. So for psychologists who do forensic work, meaning for the court, these are the truths that our science tells us. It's a masterful document, absolutely unknown in our law here, except when I use it. And I was down last summer speaking at the annual PSG conference in Fort Collins, Colorado, and there was a prof from Arizona State University or Colorado State University lecturing on a different aspect of memory science, eyewitness identification. I figured he might be interested. So I chat him up afterward, and I mentioned this publication. And I mentioned the jurisprudence, and I have a whole library on memory science here. And he was fascinated because none of this had come to his attention before. So I sent it to him. And he wrote me back and said, yeah, this is great. So it just shows you that even experts in the field can't know everything. Your typical CS worker, your typical judge, your typical custody and access assessor, your typical family therapist or parental coordinator, forget about it. What is the layman's view of memory? That it's like an iTunes song. So, I'm old school, I guess you could say. I buy my iTunes songs. I don't have a Spotify subscription. For me, it was an evolution to go from CDs to actually buying. I like to own my music. So I could play one of my iTunes songs 1,000 times, and it will recreate bit by bit by bit with perfection every time. And then when I close iTunes and that digital file is released and resaved, it's unchanged. It's the original studio encoding. Memory is the exact opposite. And that's stark description, right? When we're trying to explain something somewhat nuanced or complex, we use visuals. So the visual of memory being the exact opposite of playing a digital music file is a great visual. Memory is a reconstructive process. The minute you accept that science, and I'm telling you, that's the science and that's the law, can you ever look at a child's allegation the same way ever again? You can't. In this case, I've left this slide up. Child interviewed. No, my dad didn't do that to me. 1 year later, mom comes back with something even grosser. Child re-interviewed. No, that didn't happen. 1 year later, mom's back a third time with even more disgusting, grandiose allegations. Child interviewed again. At that point, the society had had enough, referred the family to an outside expert. The outside expert said, this is destroying this child. You need to do something. And the society brought a protection application. Mom goes out and retains, wealthy family, retains aggressive counsel. Society chickens out and backs off. But through the Superior Court process, we deal with it. And the Superior Court judge says, this got to stop. You don't realize it, but you're destroying your child. Dad's safe. Get on with it. Luckily, the father in this case was so good, so well bonded, that the child never lost faith in him. But other children, when you are repeatedly interviewed, can lose faith, lose that sense of you. Okay. A case straddling two agencies. Bad result. Delayed therapy, too much time, too much water under the bridge. Innocent parent runs out of emotional, financial, and time and gives up. Failure of the system. Here's another case. False allegations of sexual abuse. Prior to my involvement in the case, father agrees to family supervised parenting time. It's quite obvious that doesn't make sense. OCL is appointed who does not have the necessary specific expertise, so it's unhelpful. For those of you who understand what I'm saying, this is very much like the Hotel California. You can check in anytime you like, but you can never leave. What I mean by that is it only took an allegation to impose family supervised access. Then I effectively prove a negative. Do I need a trial to get rid of it? Apparently so. Hotel California. So we go through a trial. I prove a negative at the trial. Judge takes it very easy on mom. Should have been supervised access only. Instead, primary residence to dad, secondary residence to mom, with a stern warning that if this ever happens again, that'll be it. Mom, who was in league with a whole host of radical feminist, we believe you sorts of organizations, her ego couldn't survive the fact that she was called out by a court after a full trial, kills the child, kills herself. Hindsight's 2020, but was this a personality disturbed parent? We tried to make that point. So, they say you read about this stuff in the paper. Does this stuff actually happen? Yeah. Happened to me on a case. Did we predict that she was going to kill herself and kill the child? No. Did we try to make the pitch that this is a true believer whose ego is wrapped up in the allegations? She'll never stop. You gotta just impose supervised access. That was our pitch. Would it have saved the life of the child? Of course it would have. Hindsight's 2020. New Brunswick. All kinds of allegations made against a simple, loving dad. Mother keeps moving, dad keeps trying to find mother and child. All kinds of allegations about dad's mental health or whatever. It's got to prove a negative. Eventually, it's starting to close in on mom in Ontario. So she takes off and abducts the child to New Brunswick. By this time, the child is taken from mom by the New Brunswick Child Protection Authority, but they turn against dad. Why? Because they're not thinking forensically. Child wants nothing to do with you, sir. We're here for the child. Disaster.
Sorry, Brian. I don't know how much time we've got left in your presentation. We've got about, I know your time is
Yeah.
precious. And,
Yeah. So, like you can see these slides go on and on and on. This is a redacted case where this is York CAS, and this is one where they did a flip flop, and we got them on side. Now they really do see it our way. Sorry, this is also Brampton PLCS. So that's to just give you a sense of the difficulties that societies are struggling with. Okay, so I'm going to stop screen sharing this one. Okay, so this is now the presentation that I did at the 2022 conference. So everybody should be seeing generally how do you address false allegations. And again, I'm happy to provide this one. But if I go right to the end, there's a lot here. As you can see, this is quite dense. Okay, but the secret sauce comes at the end here. Series of slides, about 15 or 16 points, how you prove a negative. And I give you the tools here, 15 or 16 tools. Tool 1, assemble objectively determinable facts and observations from third parties, parents and children's behavior during the period straddling the timeline, etc. That's what helped me turn around this ongoing Peel case. Tool 2, look for the illogical or typical manner in which the allegations arose. We have a lot of cases where it's silent, it's quiet, it's peaceful, but then it's going back to court for some reason, and all of a sudden there's a flood of allegations. That pattern of when and how the allegations arise is suggestive of falsity, because the human behavior isn't changing. The catalyst for the allegations is you're heading back to court for some reason. Okay. Tool 3, it's recovered memories. Child's been interviewed 15 times, not a word about A, B, or C. All of a sudden, 16, like Columbo, the old series, what about, and the child suddenly remembers something, not how memory works. Tool 4, third-party reports, suggestive of some other dynamic. Tool 5, a trial balloon. Don't tell the other parent, but the child said this and that. Why? Because they know it's probably not going to stick, and they don't want it held against them for making a false allegation if the society doesn't verify it. That's a real tool. If it's real, if you actually believe it's real, you want the other parent to know. Forget about the litigation. You want the behavior to stop. They just don't want the society interviewing the other parent. It's a classic giveaway. Tool 6, child behaves in a way different than what they're saying. Oh, triggered when I'm with my mom, triggered, memory triggered. But then when people see the child in private with mom, there's no anxiety. classic diagnostic. Tool 7, the devil's in the details. We use charts. You know, we had a long motion. You put in a whole series of affidavits. You didn't say one word about this. All of a sudden, 3 years into the case, you're anchoring on some event that supposedly happened prior to separation. I charted one case for a successful alienation trial. Children were placed totally with dad, survived, went up to the Court of Appeal upheld, where there was one incident where the younger boy was sleeping upstairs and the daughter was just going to go up the stairs to the bedroom level and make some noise, whatever. And the father kind of interceded, put his arm on the daughter, said, no, son's sleeping, to stop her from going upstairs. Daughter tripped or something because dad kind of like pulled her back from going upstairs. This gets reported by mom sequentially as he tripped the daughter down the stairs. He pushed the daughter down the stairs. And then eventually he threw the daughter down the stairs. Each one completely untrue. Mom wasn't there. But the whole thing, context missing, and the whole thing takes place downstairs with the daughter going upstairs. The evolution, let alone the ridiculousness of saying that this loving dad is going to throw his daughter down the stairs. This same mother testified that she worried every time the kids went, if they went, because they often didn't go, to their father, that they'd return home dead. Really? So I guess you're not actually encouraging them to see the other parent if that's cognitively you have that worry. Okay? So that's number 8, a discontinuity. Or saying one thing in one form, saying something else somewhere else. Tool 9. Make sure that the interviews of the child are pure. Tool 10. We often have parents prepping kids for their interviews, or I recently had one, it's still ongoing, for the child's testimony in a criminal trial against one parent. The other parent was reminding the children of their lines in the car on the way to court. Yeah. If it actually happened, let it go. If you have to practice their lines with them, something's wrong. Tool 11, draw diagrams of the scene. So in the one where unfortunately the mother killed the child and killed herself, some of the alleged abuse took place in the first floor living room den area. The kitchen has an open view of that area. So I had my client diagram it out. What does the first floor of your house look like? Then I cross-examined the offending parent using that diagram. So tell me, you're in the kitchen, right, when all of this is going on, and you have it's a big open plan sort of thing, and you're walking back and forth, but you're saying, let me ask you about the child's father. He's an engineer, right? He's a very smart guy, right? You've always said he's a very smart guy, but he's going to be sexually abusing the child in the living room with you 10 feet away in an open plan kitchen, able to see. That's what you're telling us? Where were you? Where was he? Where did this take place? And you know, that it was over after that. So I used demonstrative evidence. Tool 12. The timing, is it logical? If it was true who would it be reported to first? Who would it be reported to? It would not be kept in the quiver to be used 3 months later. It's just not how people act. You're going to be curious. You're going to be concerned. You're going to raise it right away. Okay. Tool 13, I already gave you an example. It evolves over time. I had one case recently, false allegations of sexual abuse, where a 14 or 15-year-old daughter, where when they were much younger as an intact family, there was a process of, bedtime story routine, and father would like rub her back, tickle her back. It was a treasured thing. Mom did it as well. It was all done openly with all three kids, nothing secretive about it, very endearing. So you fast forward, child interviewed by the police. Yes, every single night for years, my father asked me to take off my bra so that he could tickle my back and whatever. And of course, I said, that's yucky, Dad. I'm not taking off my bra. Okay. Brand new. Never been stated before. Father charged, cut off from child. 6 months later, same child, now 15 to 16, being interviewed. Every single night for years, my father took off my bra. Part of the bedtime routine. Like, sorry. Firstly, memory degrades over time. Secondly, you're already 14, 15, and you have a novel story. 6 months later, you have a completely different story. This isn't a sudden revelation. The whole thing is false and thankfully was found to be absurd. Inconsistencies over time. Now, tool 14, very important. The concept of hypervigilance. Pre-separation or year one after separation, somebody is accused of a false allegation. Investigated, not verified. That person is going to be hyper vigilant for years to come. If there's any other allegation that's not anchored in the past, but anchored, because usually when the child's interviewed, tell me about everything that ever happened with parent A. So it tends to whitewash the past. So the next false allegation has to be anchored in the post-separation period after the previous interviews. But you're talking about somebody who is now inoculated, hypervigilant, going to be afraid to be alone with their own child, going to have witnesses, going to have cameras in the house because of the fear of another false allegation. That is the safest time in history for that parent to be alone with that child. They know they're under the microscope. They know that the other parent is just searching for anything to twist. The base rate will be close to zero. People don't understand hypervigilance. Tool 15. Having one parent and child or children, having a child repeating, does not lend reliability to an assertion. A child's voice is consistent. Right. It's consistently wrong. It's consistently programmed. Just because they keep saying the same thing doesn't lend reliability or credibility. So I mentioned demonstrative evidence. The impact of false allegations leaves a taint even after you prove that they're absurd. Still leaves a taint. That's why they're used. We do have a body of case law holding parents accountable for the false allegations. It's not as thorough as we would like it to be. If everybody knew that you'd actually be accountable, there'd be much fewer false allegations. Um, just some other references here. And then I guess I got into gatekeeping as an independent item, but I wanted to focus today on false allegations. So there we have it with 3 minutes to spare. But I'm happy to take questions, and I hope you found this interesting.
That was a great presentation. Thank you very much, Brian, for doing that. And I think there's a whole bunch more that we'd love to kind of delve into, and maybe we can have you back for kind of a more robust question and answer period at some point in the new year. If you're
I'm happy to do so.
okay, that'd be great. So I got a couple of questions. Wayne was the first one to submit a question. Wayne, do you want to ask your question verbally, or do you want me to read it?
Yeah, it kind of changed, but I think I got it concise here. My ex made a public YouTube video admitting she made false allegations. I have a copy of this. She's since taken it down. So my first question is that, can I still use that? It's her presenting herself, because you said something about when I'm not a party to it, is it still admissible? So that's the one part. And then the other part was CAS. I went to the top of the complaints process with CAS. I have a lot of issues where I've had conflict with people in the past. I'm working on trying to work with them, but there seems to be this heavy bias. They will not give me an update in over a month, despite the judge saying this guy needs regular updates. And so I'm wondering, can I still go through that complaint process? Because someone said if it's a current child protection matter, you can't file those complaints, the normal complaint process.
All right. So the first one, in terms of admissibility, generally, if it's relevant to the protection of children from risk of emotional or psychological harm, meets every test of relevancy, and there's usually a way to have it admissible in whatever the forum is. Nobody should turn a blind eye to potentially crucial evidence for child's well-being. There's even case law that says certain rules of evidence are relaxed in cases of child protection concerns. In terms of an internal escalation while a case is going on, it's only the Child and Family Services Board that root outside the agency itself, that generally they won't touch it while things are ongoing. The whole point of the informal and formal internal escalation is, yes, it's specifically meant for current ongoing matters.
Okay, that's very helpful. I can speak to the manager, and thank you. That was wonderful. I appreciate you being here.
Right.
Next up, we have Nick, who's I guess somewhat offline. He's it's loud where he is, so he's just asked me to answer or to ask this question. He said there was a complaint made against me by my ex at CAS. They tried to contact me several times, but I didn't respond. Finally, I received a letter from them saying the investigation is closed, as they couldn't contact me. Should I expect them to contact me again in the future? And is this investigation going to be going into the record?
Okay. Everything the CS touches goes into the rec. There are very strict provincial level documentary requirements for child protection authorities. Yes, it's all going into the record. How much of what you tell them, the only way to control that is to write them, because the emails, the letters get captured as part of CPIC. Once an investigation is closed, you won't be hearing from that person again. The family might be referred for ongoing services, in which case there'll be a handover to an ongoing caseworker, and then you'll establish a relationship with that person.
Okay, that's great. Thank you very much. Chris, I think you're next.
Yeah, so Brian, first, thanks so much for being here. I think you gave a lot of really great information today. I just have one question and then a couple comments. So I know that you've recently partnered with my civil lawyer, Ray Collotti, and I think that that's excellent that you guys are doing that. So my question is at what stage of an allegation that's made to CAS, whether it's a foster family or a separated couple, should a civil claim be started? And my thought is kind of the more people are fighting back against CAS, the quicker we're going to get to change. So at what stage should a civil claim be made? My civil claim against CAS started in 2015. My not guilty verdict wasn't until 2019. So the civil claim was kind of contingent upon the outcome of the criminal case. But just wondered if you had a thought on that.
Okay. The sad part is that when you go at them in these other forums, they shut down, they stop refusing to engage with you, you become the enemy, they retaliate against you, you're a bad actor. So use your rights and focus on what they're getting wrong about the child. They can't easily retaliate against you. As a matter of fact, workers hate for their incompetence to be exposed. So use your statutory rights. Not
Perfect.
being the aggressor here, I'm trying to protect my child. It's unfortunate you don't have training forensically. And so I'm using the rights I have to escalate matters to people who are more experienced than you and who may be able to have a more insightful and informed perspective. And you push it up the chain.
Yeah, I think
After the fact, sure, you can sue them for malicious prosecution, as Ray and I are doing on an Orangeville matter, where the trial court really called them out. But when you're at war with them during their services, we're just trying to convince them, just trying to bring them on side. Here's this, we're entitled to a meeting. Will you meet with us? Here's this binder of materials. Look at this, your worker's missing that, etc. You just work the problem because you're generating evidence for your civil suit to come.
yeah.
When
Well,
you're helping them correct their own errors and they refuse to correct their own errors, they look very guilty.
yeah, that's great. I think that's really good advice. The second thing, and I know you touched on it in a couple of your presentations, but I just from my own experience in dealing with CAS and frontline workers and supervisors. So our very first meeting with CAS, we were asked to come into their office, and they didn't permit recording in their office. So every meeting after that, we had them come to the house. Before they stepped through our front door, we made them aware that we were recording our conversation. The other thing that we did, because we were finding that the notes that they were taking, we would get a kind of an update on the notes that were taken, and it wasn't at all, it didn't match at all what was said during the meeting. So
Exactly.
we asked to review the notes before they left our house. Any blank spot on the page, we X'd out. And we signed the bottom of what they wrote down while they were in our house. It was all recorded. So we did have that backup. The other thing is, so for some of the guys that are dealing with CAS, and I found this out, and Brian, you can probably help with the logging system in CAS and how numbers are supposed to correspond as they're entered. Through the disclosure that was given to us, we found that notes were added after the fact. So in 2015, they went back to August 2008 and added a note. in there where it was completely inaccurate. But through their own numbering system within their database, we were able to find that out. So
And well, that's a great point. And if they fudged it, because CPIC is pretty sophisticated, and once you have a note, it's supposed to be indelible.
yeah.
If they entered something 6 years later, it's absolutely unreliable.
It wasn't only one thing that they added. I don't want to take up too much time. I see Vlad and Kane both have their hand up, but yeah, there were a number of entries that were added after the fact. So just want everybody to make sure you really have somebody that understands that record keeping system when you're looking at the disclosure from CAS.
Yep.
And yeah, again, thanks for being here, Brian. Appreciate you being here.
Thank you, Brian.
Yeah, Vlad, go ahead.
Yes, good day, Brian. Thank you so much for being here. I'm glad this is recorded. I'm going to be going over this presentation multiple times with Notepad. On that conversation, as my hashtag says there, Coach Vlad, that's what I am. And I've been self-representing myself within family court and now within criminal court proceeding, all stemming from family's issues with my ex and my son, now 7.5 years old. Long story short, I think I haven't achieved the success that I wanted. One of the main reasons is because I didn't have a good coach in my corner. And I would like to explore a possibility of potentially you being in my corner as a lawyer more on a consulting basis, because I still intend to be a self-representing in both matters. However, with your knowledge and your expertise, I know you're going to be essential to my success. And so is that something you're open to discuss? And we can do that obviously off the Zoom.
For sure. And I'll just let everybody here know, and you can let your friends and your groups know. I'm well aware of the challenges with affordability and also with time, because I work 7 days a week. So I do a lot of strategic consults all over North America, where I can help more kids with a fairly light footprint on my time commitment and therefore the associated costs. So strategic mandates, I love them. I get to help more kids that way.
Awesome. So I'm just going to email you and we can go from there. Is that okay?
Sure, for sure.
Wonderful. Thank you for your time again. Really good.
Thanks, Vlad. Yeah, Kane, I think last question. I think Brian's got to wrap things up, but Kane, go ahead.
Thank you for your time, Brian. I really appreciate the things you said today, especially the part about proving a negative, which is of deep interest to me, just given my philosophical training and background that way. I was wondering, because I've been trying to clear up this understanding. I have kids in Ontario and I'm in the Yukon myself, so it's interjurisdictional to some degree. When a child reaches the age of 18 years old in Ontario, allegedly they are no longer considered, well, children really, they're considered adults now, right? So like any kind of custodial parent is not necessarily privy to their records simply because they want them. So like a litmus test for that would be for, say, my ex to, demand the academic records of my children who are in university, and they would say no, because the child is an adult. So when it comes to my contact with my adult children, which I haven't had except to ask for money in like 3 years, and I haven't seen them since 2017, unfortunately, am I allowed to just write to them or to, get a private investigator to find out their contact information so that I can have an organic one-on-one conversation with them? I have no orders against me. I have no involvement with the police or CAS. The court orders do not state that I cannot contact my children.
Okay, so of course, it's like any other adult out there trying to contact a long lost friend.
Mm-hmm.
You're allowed to try and find them and reach out to them. A good friend and colleague of mine who practices in the San Francisco, Oakland area, Josh Coleman, who's a prolific writer and speaker, has a great website, probably the world's best in terms of how to reconnect with now adult children, bit of a specialized dialogue. In terms of, you just being viewed as a wallet, we had some promising case law developing right through about 2010, 2011 about children's duties. If you want help, I mean, you got to have a relationship. And that kind of petered out a bit, but at a minimum, you're entitled to their registration, the courses they're taking, the marks, the use of the funds. There's certain things, certain informational things, if they want contribution for food, shelter, clothing, tuition, once they hit 18, they have to provide you with. Law does not require them to have a relationship with you. There is law that if a child completely 100% unjustifiably rejects a parent, tough standard to meet, but there are cases where you can meet it, then your obligations cease unless they work things out with you.
Right.
And I just argued a motion about that last week. So that's kind of the lay of the land with adult children, but you want to reconnect, and I would use helping you pursue your dreams in university and whatever. Go ahead and send a note to Josh Coleman. Tell him I referred you, and
Okay.
you'll see he'll be very, very helpful. And if you go to Indigo or Amazon, pick up some of his books, you'll get tremendous value just from a softcover book.
Okay. And are you able to put a link to his website in the chat there?
I can try and find it. It's Dr. Joshua Coleman, Coleman. Let me just see if I can.
Perhaps, Brian, if I can jump in here,
Sure.
you mentioned you might be able to share your slides. If you'd be able to.
Yes.
Put,
So what I'll do is this. Wayne will remind me. I'm going to send you both slide decks. I'm going to send you the British Psychological Association publication on the law of memory science, and I'll try and find some related stuff. And to your point, I'll include a link to Josh's website.
Thank you very much.
Okay, that's great, Brian. Thank you for your time. Hopefully we can schedule another one of these in the new year, because I think that the information you presented was absolutely spectacular, and we really appreciate your time today.
Great, my pleasure. Thanks for having me here, and good luck to everybody. And sure, I'm happy to help as many kids as I can. So, just spread the word. Sometimes just a couple of hours, I can help a family.
Perfect. Thanks so much,
Okay,
Brian.
thanks. Everybody have a great day.
You too.
Bye for now.
Have a great day.
Thanks,
That was
guys.
amazing. I'm glad that's recorded.